I've done videos before about how cannabis has basically been legal since 2018, and that THCA hemp is legal. Now, like a real lawyer, I'm going to argue completely the other side. You get to understand it all, and some insights on how a lawyer thinks. You have to have someone argue against your point of view to survive the adversarial nature of the system. Lawyers are kind of like pro athletes. On any given game, they can either win or lose. Plaintiffs and defendants, just like dark shirts and light shirts at the big game. So let's flip the script with your favorite cannabis lawyer and examine why the 2018 Farm Bill did not legalize intoxicating hemp, including THCA flower, vapes, or diamonds. Then we'll cover Delta-8 at the end, so stick around. People think that it is all federally legal hemp, any intoxicating hemp derivative, so long as it is Delta-9 THC compliant. It's everywhere, being peddled online, even with Facebook ads driving online traffic to these online dispensaries. They claim that it is all federally legal, despite not shipping to several states, which is a growing number of states. Plus, the off-limit states are often where cannabis is already legal, like Washington, Colorado, Oregon, for example. So how do we determine if it is legal or illegal? We have to examine the text of the law. Then, if we have any absurd results that frustrate common sense, we look at the intentions of Congress. We are going to use the absurd result principle to invalidate the definition of hemp that includes any potentially intoxicating versions of it. We don't see anyone else raising this, and no action to shut down the hemp industry has yet been made by the federal government. However, states keep cracking down on it, and the 2023 Farm Bill is due sometime this year. Let's start with textualism. The core rule of statutory construction is called the plain meaning rule, which is where you give the words in the law their plain meaning according to the text of the law. The 2018 Farm Bill's definition of hemp has its textual meaning of the Delta-9 THC threshold, but it does not match the intention in Congress's action to create a broad hemp industry while keeping intoxicating cannabis as a controlled substance. The 2018 Farm Bill defined hemp with 0.3% Delta-9 THC, but also required post-decarboxylation for testing compliance purposes. Hemp's textual definition under the 2018 Farm Bill is as follows. Hemp. The term hemp means the cannabis plant sativa L and any part of that plant, including the seeds thereof and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a Delta-9 THC level of not more than 0.3% on a dry weight basis. And any state or tribal plans to produce that hemp required a procedure for testing using post-decarboxylation or other similarly reliable methods of Delta-9 THC concentration levels of the hemp produced in the state or territory of the Indian tribe. Almost 11 months after the 2018 Farm Bill, the USDA published its interim final rule in late 2019. Hemp only has to be tested for total THC no more than 30 days before harvest. But does that mean that if you are caught with THCA flower and it is tested by law enforcement and surprise, surprise, it was way over the 0.3% line? Isn't it absurd to argue that it was hemp and not marijuana because of its total THC amount? The Farm Bill requires testing hemp using post-decarboxylation or other similar reliable methods. So using gas chromatography to heat all the THCA to its THC level would be one way. Or the rule explains how you can multiply the THCA amounts by 0.877% and add that to the amount of the Delta-9 THC to get a total Delta-9 THC. None of the THCA flower does this. They only pay attention to the Delta-9 THC levels and actually advertise their THCA levels and 2018 Farm Bill compliance. The USDA rule only requires total THC testing no more than 30 days before harvest. After that, when you harvest and begin unlicensed retail sales, the companies are ignoring the total THC aspect of the test and calling it legal hemp because it is Delta-9 THC compliant. This is the absurd result where the plain meaning of the definition of hemp cannot stand by the ambiguity raised by the 2018 Farm Bill's testing requirements for total THC to ensure that people did not get high from hemp. It strains common sense to say that Congress intended to legalize marijuana, which is why they defined hemp with Delta-8 THC because it was the only known psychoactive cannabinoid found in any meaningful levels in the cannabis plant. The 2018 Farm Bill wanted to confirm that low total THC and mandated its testing so that hemp would not get people high. Evidence of this intent is found in the congressional record and testimony regarding why hemp should be legalized because it is a good agricultural product with many industrial applications, and it won't get you high. Right, Senator Ron Wyden? Hemp does not produce the high associated with marijuana. The only thing you are going to accomplish by smoking hemp is wasting your breath, wasting your time, and wasting lighter fluid. That is pretty much what you would accomplish. Senator Wyden said that to Congress on April 12, 2018. The rule providing for testing causes this absurd result, allowing THCA flower to flood into the market without any regulations, besides testing its total THC levels 30 days before its harvest. The law said to be sure there is not Delta-8 THC in the hemp and provided for a total THC rule of testing for that hemp being grown pursuant to a license, but this creates the very thing that it was designed to prevent. So, what is the absurd principle rule and how could it apply here? The U.S. Supreme Court first used the absurd principle rule going all the way back to 1819 in the case of Sturgis v. Crowninshield, as absurdity being a justification for the departure from the plain meaning of the words. The real seminal case of this arose in 1868 with the case of U.S. v. Kirby. Here's the facts of that case. A statute, a law, prohibited a person from knowingly or willfully obstructing the passage of the mail or any driver or carrier of the mail. Well, it so happened that Kirby was a sheriff with a warrant commanding him to arrest a man who happened to be a mailman. Unfortunately, Kirby arrested the mailman while he was delivering mail and was charged with violating the law prohibiting the obstruction of mail delivery. The Supreme Court ruled that the statute did not apply because the situation was an absurd result to allow a mail carrier to keep delivering mail despite being wanted for murder. The same thing with the THCA hemp products. They all compel the absurd result of legalizing marijuana, which Congress never intended to do when it legalized hemp. When looking at the definition of hemp in relation to the testing requirements and Congress's intent that it did not want to have Delta-8 THC levels high enough to have a psychoactive effect, even hardcore textualists on the court, like the late Justice Anton Scalia, recognized the absurd result principle in the case of Green v. Bach Laundry Machine Company, where he called the plain meaning of the statute of the case absurd and rejected the statute's language. It lacks any common sense, and it is ridiculous to say that because the cannabis is Delta-8 THC compliant, but still like 25% total THC, that it is hemp. And if the feds, or if your state's prosecutors ever tried to crack down on the legal hemp industry, the resulting case law interpreting the 2018 Farm Bill's definition of hemp may shut down a good portion of the industry. Not that any of the companies out there have a legal opinion letter that mentions anything about the absurd principle rule. Not yet, at least. We educate lawyers too on this program. So, what about Delta-8? The USDA's final rule responded to including Delta-8 THC and total THC, but declined to do so. Here's why, from the rule itself. Delta-8 THC occurs at levels that is roughly 1,000 times less than Delta-9 THC. So if Delta-9 THC was observed at 0.3% in hemp, then the Delta-8 concentration would be roughly 0.0003%. This contribution is completely negligible and contributes nothing significant to the total THC content. The trace amounts of Delta-8 THC is about 100 times less than the uncertainty of the test method, further demonstrating that it is insignificant and not worthy of consideration in the final assessment of THC for hemp compliance. The rule went on further to say this: Delta-8 THC is a cannabinoid that can be formed from Delta-9 THC. It is typically only found in very small quantities in plants. If it is found at all, and it is more often obtained by growing a plant with high Delta-9 THC and then converting that Delta-9 THC to 8 THC through an extraction and conversion process in a lab to make a distillate product. It is rarely included in total THC calculations, and many labs do not test for it. Delta-8 THC is unrelated to the 0.3% Delta-9 THC limit or the post-decarboxylation Delta-9 THC that are required and defined in this final rule. I wonder if the USDA regrets that, because as it so turns out, you can synthesize Delta-8 THC entirely from CBD using solvents. Many hemp businesses have used Delta-8 THC to build huge million or even billion-dollar businesses. The USDA was only talking about making Delta-8 from Delta-9 THC and probably didn't know that CBD could do it too from reading the text of the final rule. So did Congress intend to legalize any intoxicating cannabinoid derived from hemp? Absolutely not. Congress went to great lengths to ensure that cannabis was legal except for the intoxicating parts of it, and declined to include Delta-8 THC in the total THC because it is 1,000 times less common than Delta-9 THC as it occurs naturally in hemp. But now, it's everywhere, and without any federal regulations, leaving the states to do what they want. And now you know how the literal reading of what the law says may, in the case of THC levels found in hemp, could be an example of the absurd principle rule. If you enjoyed this video, like it, subscribe to our channel, and leave your thoughts in the comments.